That is case number 106111, State of Kansas v. Brown.
Good morning, Your Honors. May it please the Court. Lydia Krebs of the Kansas Appellate Defender Office for the appellant Kiera Brown. And if I may, Your Honor, I would like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. Unless the Court would prefer otherwise, I would like to submit issues 2, 4, and 5 on the brief and focus today on issues 1 and 3. In issue 1, Kiera argues that the district court erred in instructing the jury that it could convict her of felony murder if it concluded that she had committed a killing in the flight from attempting to commit aggravated robbery. I will argue first that that instruction was legally erroneous, and second, that the state has not and cannot prove that that error was harmless beyond a reasonable doubt. In determining whether the district court's instruction was legally erroneous, this court has unlimited review over questions of statutory interpretation. If the court agrees that the instruction was erroneous, then this court proceeds with the harmless error inquiry. That's the test that applies to a federal constitutional error in this case, and this court has de novo review over that question as well. KSA 21-3401 defines felony murder as a killing committed either in the commission of, during an attempt to commit, or flight from an inherently dangerous felony. In interpreting that statute, this court must give effect to the plain language of the statute as written and refrain from reading any language into the statute that is not found therein. Because the plain language of the statute does not include the phrase flight from an attempt to commit felony murder, flight from an attempt to commit an inherently dangerous felony, a finding that the statute applies in such a circumstance would require this court to read something into the statute not readily found therein. The state suggests various other interpretations of the statute, but I would argue that at the very least, this court must conclude that the interpretation set forth in my brief is a plausible interpretation of the statute, and thus must apply the rule of lenity to the extent that there's any ambiguity in the statute, and interpret that statute strictly in favor of Kiera. Finally, Your Honors, I would note that the state in its brief relied in part on the PIC instruction that was in effect at the time, and that also some of the cases cited in the state's brief to support its argument also relied on the old PIC instruction. The new version of the PIC instruction of the felony murder elements does remove the flight from an attempting to commit language. Unless the court has any questions regarding the first prong of that inquiry, I would next move on to the harmless error test. Here, the state can only conclude...
Before you do that, for the benefit of our audience, could you spend 30 seconds and give us the facts of this case?
Of course, Your Honor. This is a felony murder charge arising from what appeared to be a carjacking. The evidence at trial suggested that the victim interrupted someone who was trying to steal his car, that in the course of trying to keep that person from driving away with his car, the victim reached or dove headfirst into the driver's side of his vehicle, that the individual who was in the car trying to steal that car then shot the victim in the head. The car traveled a short distance and hit a lamppost, and at some point the attacker fled the vehicle. Are there any other salient points Your Honor would like me to discuss?
You can move on. Thank you.
Thank you. The court can only conclude that the district court's error was harmless if the state can prove beyond a reasonable doubt that there's no reasonable possibility that the error affected the verdict.
And why are we applying the constitutional harmless error standard here?
Because the district court's instruction deprived Kiera of the right to have a jury find every element of the crime beyond a reasonable doubt.
A due process or some other...
A right to a unanimous jury verdict on every element of the crime charged. I would argue that...
There was an objection?
I don't believe there was an objection to this instruction.
So why aren't we on the clearly erroneous?
Because I think this court has held in cases where a court fails to instruct on an essential element of the crime that whether there's an instruction or not is irrelevant to the...
You mean whether there's an objection?
Yes, I'm sorry, whether there's an objection or not is irrelevant to the test for reversal, that the constitutional error test still applies in that case. And I would argue that the error here is very similar to an error that occurs where the district court fails to instruct on each of the elements of a crime. And in those cases, this court has only found that error in the failure to instruct to be harmless where the evidence of that element is uncontroverted, where there is overwhelming evidence of the material element. And I would argue that that is not the case here. This is not a case where, like the Jessica's Law cases, where this court has found that error to be harmless. We have a defendant, for instance, testifying at trial and admitting to his age. In those cases, the element of the defendant's age is uncontroverted, and there's overwhelming evidence of that element. Here, Kiera disputed that she was involved in any way in Sappington's death. Under no circumstances could we say this element was uncontroverted, and I would argue that the evidence of her guilt was not overwhelming. While there was evidence that placed her near the scene of the crime at the time of the killing, and that in fact demonstrated that she had at some point been in contact with Sappington's body inside his car, she testified that she had come upon the scene of the crime after the car had already struck the lamppost, that she had been concerned when she saw a man's leg sticking out of the driver's side of the vehicle, and that she had opened the door and reached into the car and tried to revive him, and that that's how the transfer of the blood had occurred. Under those circumstances, I don't think the state can prove here beyond a reasonable doubt that there's no reasonable possibility that the district court's error affected the verdict. Unless the court has further questions on that issue, I would also like to address issue 3. And in issue 3,
Can I back you up just a second?
of course.
If, assuming that the jury did believe that she did have some involvement in the crime, is it really disputed that this was not an attempt to flee an inherently dangerous felony, but in the commission of the carjacking itself?
I think that that gets into what I believe was issue 2 in this brief. This case gets a little confusing because if we assume that the jury didn't convict on the theory that she was in the commission of or fleeing from an attempt to commit. So if we take that out of the instruction and we assume that the jury had been correctly instructed on the elements of felony murder, the jury here found her guilty of attempted aggravated robbery. So I think we can safely assume that the jury would not have convicted her of felony murder based on the theory of a completed crime of aggravated robbery. It found beyond a reasonable doubt that this was an attempt. So then we're left with...
But you don't have to, for felony murder, do you have to complete the underlying felony?
No, absolutely not, Your
In
Honor.
the commission of. And so she could have been charged with the completed crime and also be charged with felony murder as in the commission of, and they could acquit of the completed crime and still be guilty of the felony.
And in that case, we wouldn't reverse the conviction for felony murder because we'd assume that the jury followed the instructions and found all of the completed elements of the felony murder charge. But here I think we can safely assume, based on the jury's verdict, that the jury did not convict on a theory of completed aggravated robbery because it found beyond a reasonable doubt that she failed to complete that crime. So the other 2 theories that would be left would be that she committed the crime either escaping from the commission.
I still don't understand that. She can fail to complete the crime and still be in the commission of when the death occurs.
Yes.
Don't you agree?
I believe that I understand your point, Your Honor, and yes, I do agree that felony murder occurs when a defendant commits the killing in either an attempt to commit the crime or in the completed commission of the crime.
Well, in the commission of isn't the same as while completing. In other words, you can be in the process of committing the crime, and even if it doesn't get completed, you're in the commission of the crime.
I understand, Your Honor, and I apologize. I would disagree with that statement then based on the plain language of the statute, because it says in the commission of an inherently dangerous felony. Inherently dangerous felony is defined by statute as, in this case, aggravated robbery. Aggravated robbery has elements.
We're not talking about the crime.
And
We're
those are
talking
completed.
about in the commission of, whether that requires a completion.
I would argue that yes, in the commission of an inherently dangerous felony requires the completed commission of that crime. Otherwise, it wouldn't make any sense to include the attempt language in the statute. That would be superfluous. If in the commission of applied to felonies that are completed and those that aren't completed, then we wouldn't have any need to include the language attempt to commit in the statute. So in this case, we would have a jury verdict that indicates that this wasn't either a killing in the commission of, a completed commission of the crime of aggravated robbery, or during the flight from an aggravated robbery. The only way that this jury verdict would have come down under a proper instruction would have been in the attempt to commit aggravated robbery. But that becomes problematic for the reasons discussed in issue 2, which is that there wasn't sufficient evidence by which a jury could have found that she failed to complete the crime. If this crime occurred, it was a completed aggravated robbery because as a matter of law, this court has held that the mere presence of an incapacitated victim in a car does not qualify the robber's possession or taking of that car, and that's what we have here. If Kiera committed this crime, when she shot Sappington, the testimony established that he would have been unable to move, likely unconscious, and probably would have died within 5 seconds. And so in shooting him, she took control of the vehicle, and so that crime was committed. So I think that's what becomes problematic in this case, as far as finding that the instruction was harmless error. Even if the jury would have returned a guilty verdict, this court would have had to overturn that guilty verdict based on a finding of the completed crime, of the attempted crime, would have had to overturn that verdict for a lack of sufficient evidence. I see that I'm nearly out of time, Your Honors. If I may just briefly address the argument on the waiver to adult court. I would just point out that under the plain language of the statute, the district court erred in considering the factors of the offense rather than the factors of the offender in analyzing factor 6. That's true under the plain language of the statute, which sets forth an exhaustive list of the things the district court can consider in analyzing factor 6. It's also true from the sense of reading that statute as a whole, because factors 1, 2, and 3 already address the factors of the offense, while factor 6 has a list that only addresses the facts that are central to the offender. And so reading into that statute, the ability to also conclude that the factors revolving around the offense can weigh into the district court's consideration of that factor is contrary to the plain language of the statute, and the district court erred, therefore, in basing its review of that factor on those facts surrounding the crime. The other problem here is that the district court based its decision in part on the conclusion that Kiera's decision to dress as a boy and cut her hair short indicated that she was more mature than apparently a 13-year-old girl who decides to dress like a girl and grow her hair out long. I fail to see any distinction there, and any relevance that might have. Presumably, it's not the unusually sophisticated 13-year-old who chooses her own clothing rather than having her parents set her outfits out for her before school every day. Certainly, the district court in this case heard no evidence that that would be a trait of an unusually mature 13-year-old girl. And I would argue that this meets the classic definition of an abuse of discretion because no reasonable person would consider a defendant's fashion sense in deciding to waive a 13-year-old girl up to adult prosecution. So I would argue that that error wasn't harmless given the district court's own admission in its written memorandum that factor 6 was a very important factor in its decision here, that under the district court's own language, the state cannot prove that error harmless.
What the district court say, though, in its oral argument?
It didn't note that factor at oral argument, I don't believe.
So what do we do with the statement in the memorandum, the written memorandum, that says if there's anything that differs with the oral, then pay attention to the oral and don't look behind the curtain?
Right. I think that it's dangerous to allow a district court to give lip service to the appropriate standards under a statute and then off to the side say, but really what I was doing was this. I don't think that escapes appellate review. It's clear that he found these factors important enough to include them in the written memorandum, and I think that this court should give weight to that fact. I would say that the memorandum itself is conflicting to the extent that says, this memorandum is intended to set out the court's findings of fact and conclusions of law supporting its decision to grant the state's motion. How can we have both that and, oh, but by the way, to the extent this conflicts with what I said at the hearing, what I said controls. I don't think those two statements can exist simultaneously. The purpose of this memorandum was to set forth the factors upon which the district court relied. Even if it didn't mention that factor in its oral decision during the hearing, it's clear that the district court considered it from the written memorandum. I see that I'm out of time.
Do you have any more questions of counsel? Thank you, counsel.
Thank you, Your Honor.
May it please the court, Cheryl Lidke, Chief Deputy District Attorney, Wyandotte County. The defendant in issue number 1 is arguing that the felony murder statute does not include a killing done while fleeing from an attempted inherently dangerous felony. And they urge the court to look at the plain language of the felony murder statute to support their argument. But when I look at the plain language of the statute, it says that felony murder is a killing that's done during the commission of, the attempted commission of, or flight from an inherently dangerous felony. It does not say that it is a killing that is done during the flight from a completed commission of an inherently dangerous felony, nor does it exclude the possibility that it could be flight from an attempted commission of an inherently dangerous felony. What it says is flight from an inherently dangerous felony. And as Justice Johnson pointed out, if you're in the commission of committing an inherently dangerous felony, you may have completed the act or you may not have completed the act.
How do you answer opposing counsel's argument that we normally don't construe a statute to render part of it superfluous? And since it says in the commission of attempt to commit, if commission of includes attempt, then why did they need to put attempt?
Well, they don't say during the completed act either. They don't say what the defendant is arguing that it says.
So if they don't say one way or another, does that render it ambiguous?
Well, I don't think it's ambiguous to the point that it was clear error for this court to give it. I think it was understandable enough that it meant that it could be either during the commission of or the attempted commission of an inherently dangerous felony. To be in the flight from an aggravated robbery, a person must have committed an aggravated robbery or be attempting to commit the aggravated robbery. I think I don't think that's ambiguous at all. I think that's a very understandable concept to a jury. Never had to prove that it was flight from a fully committed aggravated robbery. I think if you look at the intent of the felony murder statute too, you get some guidance there as to what they meant when they put that phrase in the felony murder statute, and that is to hold people accountable when a killing occurs during an inherently dangerous felony. The fact that somebody is attempting to commit an aggravated robbery, I think, sets into motion all of those risk factors that the felony murder statute was intended to deter. So the fact that you are attempting to commit an aggravated robbery or robbery with a deadly weapon is exactly what the felony murder statute, I think, was intended to keep people from doing, because they ought to know, they ought to contemplate that there's a possibility that the death could occur during the commission of that. I disagree with the standard of review set out by the defendant on this issue. I think clearly this is a clearly erroneous standard that has to be used. This was an instructional error that they are claiming, an error that they did not object to in the lower court. And so I think first they have to show that the court was legally and factually incorrect. And then secondly, it's their burden then to prove that to this court that if there was an error, that it made a difference. That without the error, there would have been a different verdict in this case. As to the first prong, I would say that this instruction was legally appropriate. They appear to waive the factually inappropriate argument because they don't make any argument about that in their brief. So I focused on whether this was a legally appropriate instruction. And as I pointed out, the PIC instruction that was in effect at the time, this was a direct reflection of the PIC instruction. This also, I think, fairly reflects the required statutory elements of felony murder. If you look at those under 3401 and 3436, because to be in flight from an aggravated robbery, a person has to have been committing or attempting to commit an aggravated robbery. The intent, again, was to hold people accountable for killings that occur during certain felonies. And to hold them accountable when that killing takes place during the commission of that felony. And how can you be killing somebody during the commission of the felony if you aren't attempting to commit that felony? So we believe that legally speaking, especially if you look at some of the cases that this court has decided, I cited a couple of those, the Ransom case and the McKinney case, where this court clearly upheld felony murder on the basis that a defendant was fleeing from an attempted aggravated robbery. So you have case law, you have statutes on your side. I think it's impossible for this court to decide that this was a legally inappropriate instruction. But even if you do think it was error, I don't think that the defendant can establish that without the error, the jury would have acquitted Ms. Brown. Because to say that, you'd have to say, okay, if this error wasn't made and the judge did not give this instruction, then what were they left with? And that would be that they had to decide whether this killing occurred during the commission or the attempted commission of a inherently dangerous felony. Even the defendant in his brief concedes that there was ample evidence to prove those. And so there is no, I can't see any possible way that this court could conclude beyond a reasonable doubt that a jury would have acquitted Ms. Brown if you think this was an erroneous instruction and if we take that instruction away.
Is that our standard?
I think so. They didn't object to this instruction, and under the Williams analysis...
But where do you get beyond a reasonable doubt?
Well, I think that they have to... I thought that that's what the Williams
So we say
decision
firmly
held.
convinced that the jury would have reached a different result.
Okay. And even under that standard, I don't think you can say you would be firmly convinced that this jury would have acquitted her. Moving on to the waiver issue, the waiver to adult prosecution in this case was proper. First of all, I think the defendant confuses the standard of review. The court is supposed to look at the decision, the end result, and ask, is there substantial competent evidence that supports that decision? You don't look at each individual finding of the court and decide, well, if there isn't substantial competent evidence to support one of those findings, then the decision has to be reversed. It's an overall view. You look at the decision and say, was there substantial competent evidence to support that decision? As to the individual findings, you should ask yourself, could reasonable minds agree with the lower court's assessment of each of those individual findings? And I think the answer to that question is yes.
Even the dressing like a boy?
Well, that was just one of the things. The factor that was being considered was whether she desired to be treated like an adult. What was her home life like? What was her attitude like? What was her pattern of living like?
And I'm asking for a rational connection between that and her desire to be treated as an adult.
Well, the types of clothing that she was wearing and the way that she presented herself into society, I suppose, was something that a reasonable mind could say, yes, that's a factor that shows that she desires to be treated as an adult.
The only way I can get there is if you say that a willingness to be a nonconformist is an adult trait. But that wasn't discussed, was it?
No, I don't think that's what the judge was saying. I can't speak for more than what was in the judge's opinion, but I believe that he was just expressing that this was an example of her trying to live her life older than a 13-year-old.
Okay.
But he also looked at many other things. He looked at her school records. She basically stopped going to school before this was committed. And after she'd been arrested, while she was in the detention center, she had almost 40 separate disciplinary complaints, which illustrated her inability to conform to the norms of society. There was evidence that was presented about the juvenile system and whether it could help her and rehabilitate her and keep our community safe.
It's interesting. You kind of state immaturity as a factor we looked at for certification to adulthood, and yet maturity is also a factor that we look for too. Aren't those kind of conflicting standards that you're
I don't think I used the word immaturity. I wouldn't.
Well, I'm talking about the lack of conformity in the detention center, her acting out, those kinds of, I think can be characterized not necessarily as adult behaviors, but as immature behaviors.
Well, for me, many adults have antisocial behaviors as well. I mean, that's what we see in a lot of our criminal defendants, adult criminal defendants. So I would consider it more of an antisocial trait than an immature trait.
Isn't that why they don't allow a DSM-4 diagnosis on a child?
Oh, I don't know, Justice
Okay.
Johnson. I'm not sure what the background is on that. I think also for this court, it was impossible to get over the hurdle that this was an extremely violent offense that she had committed. It doesn't get any more serious than first-degree murder. And it was committed in a very aggressive, violent way. And I think that was a primary consideration for Judge Cahill when he made the decision to waive her to adult status. But back to the juvenile resources that were available to her, they were only going to be available until she was age 23. And I think the judge thought long and hard about the fact that she needed help beyond age 33. Even Dr. Kappa, who testified on her behalf, agreed with that it would take longer than just the next 9 or 10 years to rehabilitate her. And so I think taken as a whole, the judge's decision to waive her to adult status was a very thoughtful decision. This isn't something that he abused his discretion at. And these findings, we believe, reasonable minds could agree with him. And taken as a whole, there was substantial, competent evidence to support his ultimate conclusion. The defense has waived their argument on the remaining issues, but I wanted to touch on the prosecutorial misconduct issue, just because I was the prosecutor in this case. And I wanted to point out, as I did in my brief, that this is not a gross and flagrant case that I think is presented by the defense in their brief.
Do you agree it's error?
Well, it is error to present my personal opinion, but I don't believe that I went as far as to present my personal opinion when I said that she presented a story or a tale.
Let me tell you where I think you're wrong.
Okay.
The phraseology that I've been focusing on is where you said she had all weekend, this past weekend, to decide how she's going to respond to all the evidence that she had heard here in the courtroom last week. Now, I mean, the old adage is you don't have to decide how you're going to tell the truth, because if it's the truth, you just tell it. And
Okay.
so I think this, I can't, you can talk me out of it maybe, but I think when you look at Elnicki and the line of cases that we've got about euphemisms for lying, I can get away with, the word tale once or twice. But when you talk about that the defendant has to decide how to testify, that seems to me to be really a very strong euphemism for lying. Now, where am I wrong?
Well, I think it's akin to saying or suggesting that they've had time to think about what they're going to testify about, which was approved in the Davis case and in a whole line of other cases that I cited at page 24 and 25 of my brief. And in those cases, this court said that sort of rhetoric did not cross the line into what would be called misconduct. That we as prosecutors are allowed a certain amount of rhetoric that we can argue in our closing arguments. I only said the story word twice and the tale word once.
And I know that, and so I don't
Okay.
get real animated. Personally, I'm not real animated about that at this point.
Okay.
I'm concerned about saying that any witness, or particularly the defendant, has to decide how to tell the truth. Because the way I was raised is you don't have to decide, you just tell the truth, because it is what it is.
Right.
And so that's where I think we're at a euphemism, and I'm not taking you down the rest of the elements. I'm just saying, is that error? Is it so close to the line you got chalk on your feet, like we said
Right.
here a month or so ago?
Well-
I'm trying to decide where that fits
And
into this.
If you do decide that it was misconduct on my part, then I would hope that you would find that it was harmless error. It wasn't gross or flagrant. There was an instruction to this jury that remarks of counsel are not evidence and that they are to base a verdict on evidence. We presume that juries follow those instructions. And I can't see that there's any prejudice to this defendant given the overwhelming nature of the evidence against her.
But you demonstrated in your argument that you knew how to do it properly. You talked about, well, this doesn't really make sense, that she was trying to help, otherwise she would have stuck around, she would have told her sister. I mean, and
Right.
you showed the inconsistencies. We've said over and over again, you can point out the evidence
Yeah.
that she told in the defendant's version of events, but it's just when you get into the name calling type of thing and personalize it
Right.
rather than objectify it. And so you've indicated you know exactly how to do that. You were shooting holes in the her story, and so it really wasn't necessary to take that next step to mockery almost about telling the story and telling the tale. And I think that's what
Right.
we're talking about, being concerned about.
I understand your concern, but I didn't call her names. I didn't call her a liar. I didn't say that because she said this story that she was a liar. And all I can say, Justice Johnson, is that in the heat of a closing argument, sometimes mistakes are made. And if you believe that it was over the line, I mean, clearly this was not a gross and flagrant mistake. It wasn't designed to tilt the scales in favor of the state on purpose. And I think you should declare that this is a harmless error if you believe it was a mistake. I'll rest the rest of my issues on the brief as well, unless there are questions from the court.
Any further questions?
Yes, Chief. Did you address the argument about the factor 6 focusing?
Yes, Justice Beyer, I think, asked about that, about her dressing.
No, the factor 6 argument about when the court focused on the facts of this crime rather than focus on the offender herself. When he discussed that, he talked about, what happened and how the crime was committed and that sort of thing.
Well, I'm not sure that this is going to answer your question, but I think he had to focus somewhat on how the crime was committed as one of the factors for waiver.
That there are factors, that the severity of the crime and that sort of thing, but it seemed like when he came back to that factor, and he went through, hey, factor 1, factor 2, factor 3. And so I think the complaint is that he lost his way on that one and went back to talking about the
Well,
fact.
I think it's a legitimate assessment, though, to consider how it was committed when you're talking about how she committed it.
Any further questions? Thank you, counsel.
All right.
Thank you. Unless the court has further questions, I would waive rebuttal.
I did have a question. So if I go back to my notes.
Yes.
This was the issue of whether the federal or the state standard of harmlessness applied because of the jury instruction.
Correct.
And you made, according to my notes, a general statement about our past case law that would allow your argument. What is your best case to support your argument?
I believe it's Reyna, in which this court applied the federal constitutional harmless error test to a case involving a failure to instruct on all the elements of a crime,
All right,
which
very
is essentially what happened here.
good. All right, thank you.
Thank you, Your Honor.
Do we have any further questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.